Welcome to Employment Law This Week. I'm George Whipple. Our top story this week, the Equal Employment Opportunity Commission okays wellness program incentives for covered spouses. The new EEOC regulation will permit employers to offer incentives for an employee's spouse to provide information about his or her health. The rule will amend the EEOC's regulations around Title II of the Genetic Information Non-Discrimination Act, but will not alter GINA's general prohibition against the use of genetic information for employment decisions. We asked Frank Morris what employers should consider when designing their own wellness incentives.
Make absolutely sure that your wellness program design absolutely complies with the Affordable Care Act tri-agency regulations. That's going to put you in very good stead if you have to defend against any EEOC challenge to your wellness program. So certainly do that. Secondly, I would make sure that your wellness program can't be challenged by the EEOC as, in fact, in any way seeking the disclosure of actual genetic information and thereby preventing any claim that genetic information was infecting any employment decision. And by the same token, make sure that for ADA compliance purposes, because this would surely trigger EEOC compliance activity, make sure that you are offering alternatives so that individuals with a disability will have a reasonable accommodation for being able to get any incentives that are offered under the wellness program.
New Jersey applies Adderley's arbitration standards to employer-employee agreements. In Barr versus Bishop Rosen and Company, the state's appellate division has ruled that a mandatory arbitration provision is not enforceable because it did not explicitly state that the employee was waiving the right to bring his claim in court. This is the first published decision applying the New Jersey Supreme Court's 2014 Adderley's ruling to employers. Adderley states that an arbitration clause must explain that the plaintiff is giving up her right to bring her claims in court and be written in a simple, clear, understandable, and easily readable way. New Jersey employers should consider reviewing their agreements to ensure they include the required disclosures. And nationwide, there's a lot of litigation right now around the use of class action waivers in arbitration provisions. A recent Fifth Circuit decision upheld the Murphy Oil USA arbitration agreement that requires employees to waive participation in class actions. The decision largely reversed a ruling by the NLRB that the agreement violated the National Labor Relations Act. And a California appellate court has ruled that a class action brought by a truck driver can move forward despite a class action waiver, because the Federal Arbitration Act exempts transportation workers involved in interstate commerce. And therefore, California's Gentry Rule applies in this case. Fundamental state policy trumps choice of law provision in an interstate non-compete fight. The Fifth Circuit ruled that a non-compete clause based in Texas law does not apply to contracts between a Texas bank and its Oklahoma employees. The court found that the Texas law is in direct conflict with fundamental Oklahoma policy barring non-competes, and that the Oklahoma policy trumps the bank's choice of law provision. Businesses with interstate employees should seek counsel to assess the laws in each state to ensure that their employee agreements will hold up to scrutiny even outside their chosen jurisdiction. Now it's time for our tip of the week. Here's Tess Leopold, General Counsel for Nippon Life Benefits, with some advice on performance appraisals.
Whether your company has conventional performance management or a cutting-edge approach, feedback has a role. Constructive criticism, diplomatically delivered, can achieve 3 important results. 1, face-to-face meetings between managers and their direct reports conveys commitment and cultivates loyalty. 2, it may improve performance, which is a win-win-win for the employee, manager, and enterprise. And 3, at a minimum, it creates a personnel record which can operate as a shield for the corporation in the event that the employment relationship sours.
That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.